Okay, so when we talk about Unit 1, only one topic it has, it is citizenship. Apart from that, whatever we have is the intro part or the starting of Constitution, which is nothing but preamble to the Constitution of India. So if you have a barrack, you can keep that with yourself, or otherwise you can download the PDF as well. You can save this link with yourself. Sometimes you might get the PDF copy on internet, but that might not be the updated one. So you can save this link. Okay, this is updated by IIT Kharagpur. So this one is the updated version. Now, when we talk about Constitution of India, it starts with a preamble. And just like Constitution, there are many other legislations also that also starts with a preamble. So what is preamble? It's nothing but the introductory part of a certain legislation. Why that legislation is introduced, or what is it that we can expect inside the legislation, those things are mentioned in the preamble. So once the content is over, you will see this is what the preamble is all about. So preamble tells us why this certain legislation and what all provisions we will get inside it. Then we have provisions relating to citizenship in Unit 1. Unit 2 is relating to the fundamental rights. So before starting of fundamental rights, we have two provisions which are very important to understand fundamental rights. That is Articles 12 and 13. So those two provisions are given in Unit 2, along with that one fundamental right, that is right to equality. When we talk about equality, relating to that, we have some other rights like 15, 16, 17 articles. These are mentioned in Unit 3 along with various freedoms. Unit 4 is the remaining fundamental rights that we have, and Unit 5 is relating to the remedies that we have. In case all these fundamental rights are violated, what will happen? What remedy can we seek? Where can we go? Where should we approach? All these things are mentioned there. Along with that, we have directive principles of state policy and fundamental duties. So these are all the 5 units we have, because Constitution is again divided into 2 semesters. Constitution 1 is all about these provisions only. So it contains part 2, part 3, 4 and part 4a. These are what we have in Constitution. Okay, now when you look at the Constitution of India, you will see that the provisions that are mentioned there, right? It's organized in different parts as well as different articles as well as different schedules. Okay, so are you aware what is the difference between parts, articles and schedules that we see in Constitution?
No, ma'am.
No, ma'am, I'm not aware.
Okay. So when we talk about these part schedules or the articles that we have, right? So articles are nothing but similar to that of sections that we get in different legislations. Like if you open Indian Contract Act, you will see provisions are arranged in different sections, right? So sections are nothing but one single provision it tells about. Similar is articles we have. So one article will tell about one specific thing maybe. Okay, but when we talk about parts are nothing but relating to one specific topic. Okay, might be when we say fundamental rights. Fundamental rights is one single topic. So that is given in one single part. When we say citizenship, it's also one topic that will be given in one part. When we talk about directive principles of state policy, it's given in one part. Fundamental duties given in another part. Provisions relating to central government given in one part. Provisions relating to state government given in another part. Gram Panchayat, another part. Like that, one topic is arranged in one part. Okay, when you look at the Constitution. Now, within one part itself, there may be different provisions like fundamental rights. Fundamental rights is one concept, so that is given in one part, that is part 3. When we say fundamental rights, there are different fundamental rights that are given to us. So those different fundamental rights are given in different articles. Like Article 14 talks about equality before law. Article 15 talks about prohibition of discrimination. Article 16, equality of opportunity. Like that, one article will talk about one specific provisions. One part will talk about one specific topic or area that you can see. Okay, like that, provisions are arranged in the constitution, you will see. See, part 4, directive principles of state policy. Part 4A, fundamental duties. Part 5, union. Like that, we have all the provisions given. Apart from parts and articles, we have one more thing that we see, which is nothing but schedules. In other legislations also, sometimes you will see schedules. In some legislations, schedules might not be there. Okay, now what is schedule? Schedule is nothing but we can say it's an extra information or additional information. All right, even if you are reading the provisions only from the parts and articles, you will still be able to understand the concept. Okay, you will still be able to understand the concept, but schedule provides for some additional or extra information. If you want to know the minute details, then you need to refer the schedules. Okay, for example, we have an article talking about admission or establishment of new state. One article talking about formation of new state, alteration of areas, boundaries, or names of existing states. Like we can say how Telangana was created, how Jammu and Kashmir, which was a state, was divided into two union territories, Jammu and Kashmir as well as Ladakh. Right? Like that, we have different provisions. So when you are reading only Article 3 of the Constitution, that okay, it talks about formation of new state, alteration of areas, etc. So basically, we can form a new state. You will understand the concept. But you might feel like, okay, it is talking about states. How many states do we have in India? How many union territories do we have? What are the territorial boundaries of those states and union territories? That information you will not get in these articles, but that information you will get only when you refer the schedules. Okay, so schedules are nothing but extra information. Like first schedule talks about the states and the union territories that we have in India. Same ways, we have second schedule talking about provisions relating to president and governors of the state, provisions relating to speaker, deputy speaker, etc. Okay, starting of the constitution, what were their salaries and allowances, that is mentioned in second schedule. Similarly, we know that when a judge takes up his office, he will have to take some oath and affirmation. Same ways, different ministers, MPs, MLAs, everybody will take some oath and affirmation. So when you are reading the articles, you will know what are their qualifications, for what duration or what term they will be appointed or they will be elected. All that information you will get. But what is the oath and affirmation that they will take? That information you will not get in articles, but you will get it in schedules. Okay, so schedule is nothing but additional or extra information providing us minute details regarding certain thing. Okay, then we say that we have union list, state list, and concurrent list. Certain matters, central government would make laws like defense. Certain matters, state government can make laws like primary education. Certain matters, it might be combination of both. All that details is also given in schedules only, 7 schedules. So it is nothing but some extra information that is provided, which will help us understand these different articles or different provisions in a better way. Okay, so these are the different things that we get inside Constitution. Parts, under that we have multiple articles, and once parts and articles are over, we have some schedules as well. Okay, now when we look at Constitution 1 syllabus, only few articles are covered here. Okay, so what are these articles? Before going to that, we need to see one part, which is nothing but the drafting of Indian Constitution. So today we have the Constitution of India. If we want to know whether a certain thing is there or not, we can simply open the barrack. We can simply download the PDF and we have all the details in front of us. But how was the Constitution of India drafted? We need to know that as well. So these are the things included in Unit 1. Okay, so when we talk about Constitution of India, what do you think? How is Constitution different from other legislations that we have, like Indian Contract Act, Indian Penal Code, Companies Act, Transfer of Property Act? How is Constitution different from them? Or do you think it's same? How is it?
It's different from other act and regulation. Basically, from Constitution, all citizens of India will get some rights, duties, irrespective of if you take example of tort or contract, it will become effective only when it has its jurisdiction. It may not be the proper word, but only if two person are coming for some contract, then only contract law will get attracted. But Constitution, irrespective of all of that, it will be effective for all the citizens.
Could you ask what's the question? I didn't heard, ma'am. What's the question you asked?
Do you think that Constitution is same like all the other laws that we have, or is it different? Like Constitution, is it same like how we have Contract Act, Indian Penal Code, Partnership and all that, or is it different?
Okay.
Okay, so when we talk about
Constitution is
yeah.
Constitution is a written one, so according to that, rules are made like that. It is. I don't know.
Okay. So when we say Constitution and all the other laws, right? So Constitution is considered a supreme law of land in India. Okay, and all the other laws that we have, right? It is coming under that. So Constitution is like supreme. After that, only we have all the other laws. Okay, and why do we call Constitution as supreme? It's because it is providing for certain provisions. Like we saw, there are multiple articles, there are multiple parts talking about certain things, right? So whatever is mentioned in Constitution, right, no other legislation can say something which goes against it. If Constitution of India has said that, okay, we have these fundamental rights, we have right to equality, then there cannot be a legislation which goes against the principle of right to equality. If Constitution of India says we have freedom of speech and expression, there cannot be a legislation which goes against that certain provision. Okay, so whatever is written in the Constitution, all other laws will have to abide by it. If it is going against what is written in Constitution, that certain law may be considered as unconstitutional. It would be declared as not applicable. It would be declared as void, that from tomorrow this law is not going to be applicable because it has violated so and so provision of Constitution. Okay, so whatever is written in Constitution, all other laws will have to say in the same line only. That's why we say Constitution is supreme law. All other laws are deriving their force and validity from Constitution. Other laws cannot say something or go against provisions of Constitution. That is the main difference, that Constitution is supreme, other laws are at the next level only. Now, when we talk about Constitution, what are the things given there? It provides for fundamental political code. It talks about the 3 different organs of government. What will be their powers and functions? What will these 3 organs consist of? Everything is mentioned there. It also provides for fundamental rights that apply to us. When we say fundamental rights, there may be some rights that apply only to citizens. There may be some rights which are available both for citizens as well as foreigners. Then it talks about directive principles, which are nothing but directions given to the government. Then it talks about duties of citizens. Now, duties would not be applicable to foreigners. It's only for citizens. That citizens are expected to follow these fundamental basic duties. All of it is given under Constitution itself.
Ma'am, directive principles are not legally applicable, right?
Yeah, legally it's
It
not
cannot be.
enforceable.
Okay.
Yeah, we cannot go to the court even if that is not being followed. But for fundamental rights, we can go to court. What do you think about duties? Can we go to the court if somebody is not fulfilling their fundamental duties given in Constitution?
We can go to the court, I think so. ma'am.
Okay. So as such, we can't go to the court unless and until we have a legislation. If apart from Constitution, in some legislation also same thing is said, right? Under provision of that legislation, we can go. But as such, under Constitution, we can only go for fundamental rights.
So only fundamental rights is
Yes,
claimable.
enforceable. So the Constitution was adopted on 26th of November 1946 and it came into force on 26th of January 1950. So this was the date when it was finalized that this is what is going to apply to us as a Constitution of India. But when those provisions became applicable, started to apply, is from 26th of January 1950, it became applicable. Okay, these are again two dates you can remember, important dates. Now, when we talk about Constitution of India, different scholars have defined Constitution differently. Okay, according to Aristotle, Constitution is the way of life of citizen body, how people should behave, how their life would operate. Everything is mentioned there in the Constitution. So, according to him, Constitution is nothing but is the way of life of citizen body, how citizens should behave in a certain country. According to Woolsey, Constitution is the collection of principles according to which the powers of government, rights of the governed, and relation between the two are adjusted. What will be the powers of the government? How those powers will be exercised? Who will have those powers? Everything is mentioned. Same those things we get in Constitution of India also. Powers of all the three different organs, executive, legislature, and judiciary, are clearly specified. Plus, it also talks about rights of the governed, as in rights of the citizens. It tells us what all rights we have, as well as relation between the two. What is our relation as a citizen with the different organs or with the different departments? Everything is specified in Constitution. Okay, sometimes you might get a question like define Constitution, and after that maybe what are the features of Constitution or something like that. So try to remember these definitions as well, definition of Constitution. Okay, and even if it's like a general question that define Constitution, there also after giving an introduction, you can give two definitions if you remember. You can add those definitions as well. There is no harm, and after that you can move to the maybe different types or maybe the different features, whatever is the question. Okay, in fact, this was a question from previous year question paper. Define Constitution. What are the different kinds of Constitution? So definition you can try to remember. Okay, now when we talk about Constitution of India, it is considered as supreme law of land. But how was it drafted? Okay, so Constitution of India was framed by a constituent assembly, which was set up under Cabinet Mission Plan of 1946. So when India got independence, right? So when it was decided that India will get independence, if everything was governed, everything was taken care by the Britishers, right? All of a sudden, if all the powers and everything is given to Indian leadership, it might create confusion, right? Because they don't have any experience or anything. All of a sudden, everything is transferred to them means it might create problem. So Cabinet Mission Plan was set up under which it was decided that how powers would be transferred to Indian leadership in an organized way. So under this cabinet mission plan only, 22 different committees were being, like constituent assembly was set up, and under that we have different committees. Okay, because constitution is like a very big document, a lot of things are there, a lot of things need to be taken into consideration. So different committees were being framed in order to cover different topics. And all these different committees had to do their research, had to do their analysis, and finally submit a report to the drafting committee. Okay, so drafting committee is very important committee. All these other committees had to submit a report to the drafting committee. And finally, all these reports of 22 committees taken together, drafting committee framed something called as a draft constitution. Okay, so on the basis of those 20 reports of the remaining committees, a draft constitution was prepared by 7 members drafting committee with Dr. B.R. Ambedkar as the chairman. They framed a draft constitution. Now, even though different committees were framed, a lot of different members were there who gave their viewpoint and everything, there still was a possibility, right, that it was only a limited section of population who were involved in drafting of the constitution. But there is a possibility that from common men also, people might have better suggestions, people might have better viewpoints, right? So what they did is they did not finalize this draft constitution, they simply prepared the draft and they published this draft in January 1948. Okay, they published this draft and they said that you have 8 months of time. You can read this draft constitution, and if you feel anything is wrong there, any mistake is there, you can tell that. If you have any better suggestions, you can provide that. Or if you have any proposal for any sort of amendments, you can let us know that also. You have 8 months of time to do that. And during this time, they received total of 7,635 suggestions or amendments from lawyers, from professors, from journalists, from different groups or different classes of people. They gave many suggestions that maybe this improvement can be done, this change can be done in the draft constitution. And there is a possibility that some of those provisions might be repeated also. Some of those proposed amendments might be repeated. Whatever I feel, you might also think the same thing. So out of those total 7,635, there were 2,473 suggestions which they took up, and there were debates on them, that whether it can be incorporated or not, what will happen if we incorporate it, what will happen if we ignore it. All those debates continued for 114 days. And these are known as constituent assembly debates. In any law library, you would see big volumes like this, wherein in detail, the debates are being recorded, okay, it's being mentioned. So debate relating to fundamental rights, debates relating to a certain provision, everything you will see in these volumes. So in this entire process of framing the committees, then getting their reports, then publishing the draft, then the debates, and then finally having the constitution, this entire time taken to finally have the final copy of constitution is 2 years, 11 months and 18 days. That much of time it took to finally have the constitution ready. And total amount spent was 6.4 crores in this entire duration. Okay, so there are these 2 dates which are important. When Constitution was adopted, this is also celebrated as Constitution Day or National Law Day. And then we have 26th of January when it was finally brought into existence, it finally became enforceable. Okay, and when we talk about the Constitution of India, it originally had 22 parts, like we saw, right? Different parts are there. So total 22 parts were there, 395 articles and 8 schedules were there initially when Constitution became applicable. As in initially in 1950, Constitution had 22 parts, 395 articles and 8 schedules. But there were a lot of amendments, right? So what are amendments to Constitution?
Changes made according to time by the Parliament.
Yes, Parliament. Only Parliament is having power to make changes in Constitution. So whenever changes are made, right, from time to time, a lot of changes are made, including those as of now we have 448 articles, 25 parts and 12 schedules. So this is the present number that we have: 448 articles, 25 different parts divided in 12 schedules. Okay, but even today, if you look at the Constitution, see, last article is still 395. But we are saying 448 articles are there. So why so? Why? What about the remaining articles? Is it mentioned in the... Okay. So when we say this amendments are being made, right, what happens is, might be in 1950 some constitution became applicable. After that, we realized that, okay, we need to add something as a fundamental right. Or might be you have realized that we need to add something as directive principles. So fundamental rights and directive principles are already included in two different parts, right? Part 3 talks about fundamental rights. Part 3 talks about fundamental rights, and Part 4 talks about directive principles of state policy. So after Constitution became applicable, after that, if we feel like we need to add something in Part 3, then we have the right of adding it in Part 3 itself. We don't need to add it as Article 396, 397 and like that, because otherwise this parts would have no meaning, right? It would become meaningless and Constitution would become all messy, right? So whenever you want to add something, wherever you want it, you can add there only. So if you talk about fundamental rights, say right to education was added at a later point. So it is added as Article 21A. So wherever you feel like you can add it after that article, just you can add A, B, C, like that. You can keep on adding. Like A, B, C, D, you can keep adding, there is no harm in it. Okay, so when we take all of these as an example, we have total that many articles. And not just about articles, even parts can also be added. Like see, part 4A, this entire part was added at a later stage by way of amendment only. Part also, article also, that is also completely okay.
76, right?
Yes,
1876.
80, yeah, 1976, 80. So this was added. There is one more provision wherein a lot of, say this one, so many provisions are added. Oh, Z, then ZA, ZB, like that. So there is no harm in it. When we take all of these things together, then we get this particular number. That's why even today, last article will be 395 only. If at any point in time, Parliament feels like we want to add one article at last part of the Constitution, they can name it as 396. There is no harm, but as of now, we have these articles. Even schedules were also being added, parts were also being added, articles are definitely added. Okay, so as such, you will not get question from this intro part, but this intro part is very much needed in order to understand Constitution. And also, when you know these things, right, that these many articles are there, when Constitution was adopted, definition, you can include that while writing an answer. Somewhere you can include that as well. Okay, so these are certain things which are very important for us. That Constitution of India was framed by Constituent Assembly, and Constituent Assembly was set up under Cabinet Mission Plan of 1946. Initially, we had these many articles, parts, and schedules. As of now, we have these many. Constitution was adopted on this date, which is celebrated as Constitution Day or National Law Day, and it came into force on this day, celebrated as Republic Day. Okay, so these are the intro part that we have from Constitution of India. This is clear, right?
Clear,
Yes.
ma'am.
So after that, only whatever is given in the syllabus, right? That will start, like meaning and definition of constitution, different kinds of constitution, etc. Okay, now the first thing that we have is types of constitution. What are the different types of constitution? So you might have heard that Indian constitution is the lengthiest written constitution, like that we see. Right, so when we talk about written constitution, we can say that constitutions may be written and unwritten. So what is a written constitution? It means that just like how we have other legislations, Indian Contract Act, Partnership Act, everything is written very clearly in one single document. Same ways, Constitution is also written just like a statute in one single document, everything is there. So if you want to know whether a certain provision is there in Constitution or not, you can simply open this PDF and you can check there. If it's written means it's there. If it's not written means it's not there. It's that easy. It is consciously framed and enacted constitution. A special committee itself was, committees were being formed, assembly was being set up, they prepared reports, draft was published, right? It was, everything was consciously done. It's not like all of a sudden from somewhere we got the constitution, but it was something which was well planned and in an organized way it is being enacted. And it is formulated and adopted by Constituent Assembly in case of India. In some other countries, it might be by way of a council or by way of the legislature, like how Parliament passes other legislations. Same ways for some countries, it might happen as well. So when we talk about written constitution, we have examples like Indian Constitution, US Constitution, Constitution of Germany, Nepal, etc. And there are subjects like comparative constitution. We try to compare constitution of India with foreign countries' constitutions. So there we compare Indian constitution with that of US, Nepal, etc. Okay, so this is nothing but written constitution. Everything is written in one single document. Then when we say unwritten constitution, as such, there is nothing called as unwritten constitution, but rather it means that it is not something which is drafted or enacted by a constituent assembly or by a legislature or something like that. What happens is, it is not in the form of one single document or one single book, but rather it is segregated or it's all mixed up in different forms in different sources. Okay, so it is found in several historical charters, laws, conventions, etc. There are multiple documents wherein certain provisions are mentioned, and all of those taken together is considered as constitution. They know what all things are applicable, but it's not there in the form of one single document. It's segregated in multiple things. It is a product of slow and gradual evolution, slowly and gradually, with as time passes, as people realize certain things, those are added. Again, they realize something that is added. Like that, it has gradually evolved, and it's not in the form of one single document. The government is organized and it functions in accordance with several well settled but not wholly written rules or conventions. These rules are well settled, they are being followed, but it's just that it's not there in one single document. People know their constitution, they accept it, they obey it, but it's not in a written form. However, an unwritten constitution is not totally unwritten as such. Some parts might be available in written form in some statutes, in some codes, in some legal documents, and some might be just being followed. Like that, it may happen. For example, countries like UK, New Zealand, Ireland, etc., they do not have as such a written constitution, but there are certain rules and principles that are still being followed, and those come from multiple sources. Okay, so this is the first step, written and unwritten constitution. Second one is flexible and rigid constitution. So what is flexible? In what reference we are saying it as flexible and rigid? We are talking in terms of amendments. Definitely, laws are not static. Not like today we will pass a law for the next 1,000 years we will be following it. We need changes in order to keep it relevant, right? So whether how easy or how difficult is it to make changes or make amendments, based on that we have this classification, flexible and rigid. So definitely changes would be required with time. And so we see that in constitution itself, a provision is always made on how we can make changes in constitution. Okay, so when we talk about flexible constitution is one which can be easily amended. It's not that difficult if we want to make any changes or bring any changes in the provisions. It's not that difficult. Several political scientists advocate the view that a flexible constitution is one in which constitutional law can be amended in the same way like ordinary laws, just like how we have other legislations, Contract Act, Partnership Act, how those legislations can be added, same provisions, same process will be followed in order to make changes in constitution. So if it's same like other legislations, then in that case we say that it is nothing but a flexible constitution. It's not that difficult. It's easy to make changes in constitution. Constitutional amendments are passed in the same manner by which an ordinary law is passed. It's not anything different, it's the same process that is followed. The amending provisions as given in Indian Constitution is a combination of both rigidity and flexibility. That's why we say rigidity and flexibility is a feature of Indian Constitution, because we don't have one single procedure of making changes in constitution, but rather we have three different processes. Okay, so it would depend on what is the provision all about that we are amending. Based on that, we need to select the process. So it is a combination of both rigidity and flexibility. British Constitution and Irish Constitution are flexible constitutions. Easily it can be amended. So flexible as in same process, just like ordinary laws will be followed. Now, what is rigid constitution? Rigid is one which cannot be easily amended. It is difficult to make changes in the constitution. Its method of amendment is difficult. For amending it, the legislature has to pass amendment bill. Okay, amendment bill will be introduced like constitution, first constitution amendment bill year 1951, like that they will make the introduce the bill by a specific, usually big majority of 2/3 or 3/4 of the members present and voting in the parliament. Like that, different provisions would be followed. Okay, so they need to introduce an amendment bill, and how many people need to approve that bill, that again might vary from country to country. For passing or amending an ordinary law, the legislature usually passes the bill by a simple majority. So simple majority as in 50% of the members should approve it. But when we say 2/3 of the members, as in it's more, right? If there are 100 members, 75 should be approving. So like that, it makes the process a little bit difficult. Rigid constitution is considered to be the most fundamental law of the land. It is regarded as the basic will of sovereign people. That is why it can be amended only by a special procedure, requiring the passing of amendment proposal by a big majority of votes. Because this number is higher, it is difficult to make changes. A lot of people need to provide their approval. US, Australia, Switzerland are examples of rigid constitution. But when we talk about India, it is a combination of both rigidity and flexibility. We have three different processes for three different types of provisions. I think amendment is included in your constitution too, not in one. So it mentions those different provisions or procedures. Okay, so what do you think is an evolved and enacted constitution? What might be an evolved constitution and something which is enacted?
Evolved, it has come into existence by taking time.
Yes, by taking time. With time it has come. Enacted as in something which we had planned and finally it is being introduced, right? It is enacted on a certain date. It's not like with time it has come, like that. So evolved constitution is one which is not made at any particular point in time by establishing the assembly, council or something like that, but rather it is a result of slow and gradual process of evolution. Its rules and principles draw binding force from the fact that they're being recognized as ancient, historical, time-tested, and respected customs and conventions. So, with time, from multiple sources, might be they have developed, and gradually, with time, they were being followed, or they became binding like a custom. Maybe it was followed like a custom. With time, it got the status of something which will be followed, right? It got legal recognition. Like that, with time only it has come. Some of these conventions get recognized by law, hence it becomes enforceable, while others are followed because they are supported by public opinion. Everyone supports it, like a custom, we can say. Okay, their practical utility, it's time tested. With time, we have seen that this certain thing works good. So there's nothing but practical utility and moral commitments in their favor. So it is favoring, everything is favoring it, and that's the reason we are following it. Evolved constitution is the product of historical evolution and of political needs and practical wisdom of people. The Constitution of Great Britain is an example of evolved constitution. With time, from different sources, different provisions are being taken, and finally all of it is followed, but then it's not an enacted thing, or it's not there in the form of one single document, but still it's being followed, and that is working well. When we talk about enacted constitution, it's nothing but man-made constitution. Like in Indian case, it was all well planned under cabinet mission plan. The constituent assembly was set up, so everything was properly planned, and finally we had the enacted constitution. It is made, enacted, and adopted by an assembly, maybe a council, etc., which is in case of India, it is called as Constituent Assembly. In some other countries, it might be by way of a council also. It is duly passed after thorough discussion over the objects, principles, and provisions. In Indian situation also, we have seen so many debates and discussions were there, and it took so much of time to finally have the constitution. It is written in the form of a book or a statute, or as a series of documents, and a systematic and in a systematic and formal manner. In Indian constitution also, we see everything is written or provided in such a well organized way. So this is nothing but enacted constitution. The Constitution of India, US, Japan, China are more, and others are examples of such constitutions wherein provisions are written in a very clear way and in a very well organized manner. It has been provided. Okay, is it clear? Types or kinds of constitution. So from the intro part, we have constitutionalism, features of the constitution. Okay, these two topics are remaining. After that, the actual provisions start, which is nothing but preamble and then citizenship. Okay, so tomorrow we will continue with these topics, features and constitutionalism, and maybe we can see if we can do preamble as well.